Now in this video I'm going to share with you how to fill out a Form 56 and also accompanying the 56. The Form 56 would be the Form 56F, and what we're doing with these forms at this time is making the county clerk and the judge that's assigned to your court case responsible. We're going to make them the fiduciaries. You see, things have gotten so crazy in America, or North America, that they're ignoring court cases. They're doing whatever they feel like. So they're telling you whatever you file doesn't matter anymore. You try to file things with the record of deeds. They don't want to file it. Why do you think they don't want to file your documents? It's because your documents are exposing them for fraud. And they don't want to be exposed for fraud. So, the quickest thing is to say to you, oh, we can't file that, and to make up some type of silly excuses. And the best thing to do is when you go down to the record of deeds, always make sure you have witnesses, at least 2 witnesses. Have your recorder, where people have their cell phone, record whatever they have to say, because that is going to count against them. But anyway, they act like they don't even care about that anymore. So, since they're protected because nobody puts them on the chopping block, we have no choice but to do so. All right? So, we're going to make them fiduciaries over this case. So, therefore, anything that they fail to do on behalf of your estate, your trust, they are in trouble. Because you're making a physical person, you're making that natural person responsible. They keep hiding behind corporations. For instance, when the mortgage companies file the case against you, a foreclosure case, when the mortgage company files a foreclosure case against you, they hide behind the corporation. There's nobody as far as the CEO, the CFO, putting their name as plaintiffs. It's supposed to be that way. You cannot just have a lawyer filing a case where the plaintiff is the corporation. That's a dead entity. There must be a living being backing that up. But no, they're not doing that, and that's a crime again. So they're committing another crime. This is just insane. And you bring that to light, and they're ignoring that too. Something has to be done, and only the people can stop this. They are not the law, but they have switched everything, telling you that the dead entity is the law. That is not how it works. The people created government, and government and these entities are turning around. These bankrupt entities turning around and telling you what to do. No, it doesn't work that way. Enough is enough. You tender payment, they steal the payment. No, you can't allow this. There are people who quote, pay off their homes 30 years with their hard-earned fiat dollars, which they should not have done, but they've done so, and still they take their property when they cannot pay the taxes. This is insane. So it doesn't even matter whether you pay with fiat. You can't pay anything with fiat money. That's what they're not telling you. When you use fiat money to pay your debts, you're adding to the national debt. That's not how you pay. You use the coupons on the bottom of your billing statement. That's how you quote pay. All right? But they don't want you to do that. They want you to use hard-earned fiat dollars that doesn't mean anything. That's just clogging up everything else and adding to the debt. You don't want to add to the debt. You want to discharge. That's the law. So you're going to discharge. Your bill of exchange is going to be used to tender payment. They're going to get more payment, and still they want to steal that? How many times are we going to, quote, pay them and still want to take your house? No, that's not going to work. All right, so let's go over this real quickly, briefly. Now, part 1 of the Form 56, straw man Identifying number, you got to put the court EIN here. If they refuse to give it to you, which is crazy now, I'm just learning that they're no longer making an EIN of a dead entity available online. It was so easy to search for, let's say the mortgage company, your mortgage company, the court, search and find their EIN. They have taken them down from the internet. This is crazy. And they're telling you, oh, you're not allowed to have our EIN. Really? But anyway, if they refuse and you've done everything, you can put something in here. Court EIN, I don't even know if that would fit. Let me see. Unavailable? No, it's not enough. So just put court EIN and leave it right there. They will know what you mean. They didn't give it to you. So what you're supposed to do. Let's just put that in upper and lower. Court EIN. Put your social. Don't put any dashes there. Alright, alright. Now we have the address of, your strawman address, whatever you have on file. Oh, let's put here, I forget to put the care of, alright? And put put your zip code, but put it in a box so that it's saying near to or around that zip code area. You're not putting down a zip code, because once you put these brackets around it, it doesn't mean the same thing. Okay, it means that near this area. Alright? So you can do that. If you don't want to put zip exempt, because they like to act up with that zip exempt, just put it in brackets. Alright, the fiduciary name, the county clerk. Okay? And the address, the business address, her room number, zip code, and so forth. If you don't have her telephone number, don't put it there. Don't put anything there. But if you do, put it there. And make sure you do one for the judge. Don't leave it. Oh, I have this here. The judge, make sure you do one for the judge also. You know why? Because the judge is the main culprit. So right here, I'm doing county clerk because that is, as far as the case that I'm working on right now, I'm helping someone with. That person was told, it's insane. They were told that there's no judge assigned to the case. This is the lies and the crookedness. There are no bonds and there are no judge attached to his case. So we're going after the county clerk. But still, we're going to do one also for the judge. So you're doing the same thing for the judge. But you don't know, if you don't know who the judge is, but make sure whatever you're doing, put the judge over the county clerk. But I will do both of them, because the county clerk has as much, if not more power than the judge. So I will put them both on the chopping block, and they're all in on this scam. All right? So I'm doing the county clerk first. Again, you could start off with the judge, but do both. If you don't know the judge that's dealing with your case, well, make sure you find out. If they tell you there's no judge, which we know is a lie, what you're going, it's either a lie or the court case is fraudulent. If there's no bond, it's fraudulent. There must be a bond. They're lying to you. But anyway, if there's no judge, what you're going to do, you're going to just put fiduciary name, put attention, judge assigned to this court case, and you put the court case number right there, right here. All right? That's what you're going to do here. If you don't have a judge listed, or they're telling you there's no judge, which is insane. Anyway, again, so you're going to do 2 Form 56s. Yes, you're going to. All right. So we covered that part. Let's scroll down here a bit. Well, I don't have to scroll. I'll wait till I get down here to scroll. So, Section A, authority. Check F, bankruptcy or assignment. We're not dealing with bankruptcy. Assignment for the benefit of creditors. That's what we're dealing with. G, other. And what are you going to put in the description box here? For settlement and closure of mortgage account, put your mortgage account number right here. All right? And court case number right here. That's what you're going to put there. All right? And then 2B, Now it says if 1C, 1E, 1F, or 1G is checked, we have 1F or 1G is checked, right? You're going to enter date of appointment, taking office or assignment, or transfer of assets. So what you're going to do here is add the date. Add the date the case was filed in the court, okay? That very first time they filed that court case, put the date there. All right? 3, of Section B, the nature of liability and tax notice. Yeah, they owe you. So check income, estate, and we're going to check out other also. And in the other box, you're going to put 4. Let me make that a capital F. Foreclosure and settlement of bond and issued commercial security or securities. Okay? Now, let's go down here. 4F, we're going to check off the 1041 because you know that's what you're going to file. H, and that's later on. Don't worry about that yet. H, we have other, any other applicable 1099 forms that may apply. Okay? Alrighty. Now let's scroll down. So we're going to skip all this here. Okay? We're skipping all of this. We in section C, let me see, substitute fiduciary. Check this box if a new fiduciary or fiduciaries have been or will be substituted for the revoking or term. No, we're not gonna check this box here because we have the main fiduciary, which is Janet Yellen. That's like the master fiduciary. Well, not over you or not over your power of attorney, any of that. But you know, we're not going to check that. This is just temporary fiduciary for just a specific, just for the case, a specific reason, and that's for this court case to settle it because somebody living has to be put on the chopping block. If you don't do that, they're going to screw you over. You know, and this is insane right now. It has gone too far now. Things were so simple before. Once you quote the law, they would obey. They're not obeying right now. It's like the country is lawless. Okay? So I want you to get all this done before they become so lawless where they could physically touch you and beat you and do what you don't want. I'm telling you, I don't even want to talk about that, but they look like that's where they're heading. This is insane. Anyway, part 3, you're going to put that this is court and administrative proceedings. You're going to put down the name of the court, date proceeding initiated. That's the first time they filed that case. You're going to put that date in there. The address of the court. Okay, and that's pretty much it for that. Let's scroll down just a little bit here to the end of the form, and right here it says fiduciary signature. Yes, we know that the fiduciary, which is the judge or the county clerk, you know they're supposed to sign this, but they're not going to sign it. Mark my word. I don't care what niceness you give them. What am I saying? I don't care what bribery, whatever it is, they will never sign this. You could try to bribe them all you want. You could try to say something nice to them. They're not going to sign this form. But you, being who you are, power of attorney, first in line, this is your estate we're talking about. You have the power to sign this. So sign it. Yes, you do. And right here, you're going to put receiver for estate trust. Okay? And then date it. Stamp the hell out of this document. Okay? You're going to stamp it with your 5-cent stamps on the back, bottom, right. You're going to cancel them out. You can cancel with writing your name straight through that stamp, or you can use the squiggly lines, whatever you want to do. Make sure at the top, you're going to put your dollar stamp. All right? That's what you are going to do. All right. Now, you're going to have to mail this out. You're going to mail it to several places. And again, you're going to do one also for the judge. All right. So, well, before we get to who you're going to mail this to, all the places you're going to mail this to, and you're going to add this to the court case because you want this filed on the public records into the court case as an exhibit. You have to. Also, make sure you find out where in your major city. If you're in the suburbs, look up the federal municipal court in that major city, or if it's in your suburbs, I doubt it's in the suburbs, but the neighboring major city, you're going to look up the federal municipal court. Yeah, and you're going to go and file it there too. Yeah, you got to file it there. But they're going to put it in miscellaneous, and they're going to charge you something. I don't know what they're going to charge you. Probably a $50, $60. I don't know. You would have to find that out. All right? But let's check out the Form 56 also, which you are going to attach. So you're going to do 2 Form 56s and 2 Form 56Fs. Yes. So let's get to the Form 56F. All right? So 56F, here we go. The name of person for whom you are acting. Let me make this bigger. I want you to see this as clear as day. Okay? So you're going to put down the court name right here in all caps. You're going to put the court EIN if you get it. If not, let's see. Court EIN not, yeah, it's not enough room to say court EIN not provided. Just put court EIN. Court EIN. And just leave it there because it's not your fault if they will not give you the EIN. All right? Now, you're going to put the address of the court. If you have the telephone number, do so. If not, leave it blank. Number 6, you're going to check off thrift. And if you want to do research on what the thrift is, well, you can just look up the instructions. It'll tell you exactly what that is. All right? And the instructions are usually below well, we'll check it out. All right? But anyway, you can just Google that. Number 7, check here. You're going to check if the financial institution is insolvent. Yes, check that. All right. Enter the end date of financial. We just leave that blank right here. Now, number 9, fiduciary's name. You're going to put your estate. Put your estate. Put your straw man name and comma, put estate. Contact person, that will be, you put your name in all lowercase, or you could do the last name with the semicolon, first and middle. Either way, it does not matter right now. It's going on, they cannot change it. Usually when you put it in their system, though, they do make it all caps. This is the kind of fraudulent things they do. So now that I just thought of that, let me see here if that would fit. I'll just put carbon, that Burnett. Yeah, I'm going to do it that way too. Yeah. All right? Because you just have to do things this way to avoid them committing more fraud. Because this is what they do. This is what this country has come to. All right, number 11. You're going to put down whatever address you have on file with the IRS. Your address on file, okay? So we just, we could delete this. Whatever address you have on file with the IRS. I just put that there while, I was filling out the form so that I remember to mention that. All right, and then you could put zip exempt, but just put the zip code in brackets because these people are just insane right now. Put it in brackets, but you are still zip exempt even when you put it in brackets. That's what it means. It's near there, but it's not actually there. That's what that means. All right, near to the area somewhere there. All right, put your telephone number. Number 14, check receiver because they owe you. Your estate is in the receiving end. well, or your estate, and since you're the beneficiary, you're going to benefit in the receiver position. All right, so check that. So that's it for that. Let's scroll down to the end of the form. All of that, leave that blank. And then we're going to go to authority part 2. You're going to click check here on 22C, appointment of receiver. 23 in part 3. Okay, you're going to put down the tax years. So that would be the years that you paid taxes, because you know you're paying them taxes. That's including your monthly BS payments on the BS billing statements, which should not be a billing statement, but it should be a true bill. But either way, that's what they send you, all fraud. But anyway, you're gonna put instead of just writing 1992, 2003, 2004, 2020, all of that, just put like January whatever when you first started. Well, I guess you would put down as far as your promissory note, the date on the promissory note, or the date on the mortgage. Put on the date on the mortgage. Okay, put that down here too. The date when you start paying that. You put it here. All right, and those are the tax years, and they owe you for all those years. I don't care what they say. Time for you to be the law. All right. Now, that's it. You're going to sign because you have the authority to sign that. If you don't believe me, you're going to look up the instructions. But anyway, receiver for the estate. Same thing, and you date it and stamp the hell out of it. Now, we're going to send the Form 56s and 56Fs to this certain office in now we're going to send the let me that one gotta go. Okay, we're going to send the Form 56 and 56Fs to let's see exactly where we're going to send them. We have the collection advisory offices, the contact information on irs.gov, and you can Google it if you want. Use this publication to determine which office to contact with questions about notices of federal tax lien and where to submit requests for lien-related certificates such as those listed below. So you can read through this. You can find answers to many of your lien questions on our website. There you can type a keyword of your question in the search box and then choose the resulting page matching your topic. Okay, so you can, read through this, all of this, and where we're going to send them is one of these advisory offices. And what we're looking for is right here is the international, which includes Puerto Rico, U.S. possessions and territories. And right here is number 7. So we're going to scroll further down. So it's right here. Let me highlight this right here. See, international. And number 7. And we're going to look for the address. And number 7 would be right here. And that's 1248 North University Drive, MS 5780, Plantation, Florida 33322. Okay, right here. So this is where you send. That's one of the places you're going to send them. All right. I'll put up a couple more addresses. You want to make sure this goes to the commissioner office and Janet Yellen's office. I'll put that information at the end. All right, so that you know exactly all the places that you want to send this. You want to file this into the case. You want to even file it with the federal municipal court. Okay, in your area, most likely would be in a major city with a federal municipal court. and they charge something, but not a whole lot, where you can file your documents, and most likely they'll file them miscellaneous. It doesn't matter as long as you have your copy proving that it's filed in a public court, such as at a federal municipal court, district court. Okay. All right. So there you have it. Let me make it a little bigger so you can see the address. Let's go bigger. Right there. All right. There it is. All right, and then I'm going to just put up those other addresses for you. Now here are the other addresses. Well, the main one is to the IRS Collection Advisory Office, and make sure you have a Form 2848 added to that package. Okay. Now what I'm about to share with you is FYI. You can leave this portion for another when you have some time, but this is a video where you're going to see how the banker is going to try to get away with stealing somebody's property, and he's going to be questioned and he's going to be placed in a trap. Okay, you want to listen to this closely when you have time, so you can see listen for yourself to hear the fraud being committed. Okay, and this is in a courtroom, and this actually happened. All right, so again, take some time. Well, after you do all your paperwork and you file all your stuff, come back to this video. So I just added it here as a bonus. All right, hope you enjoy it.
A.
Well, this is a promissory note.
Is there an agreement between Mr. Smith, the borrower, and the defendant?
Yes.
Do you believe the agreement includes a lender and a borrower?
Yes. I'm the lender and Mr. Smith is the borrower.
What do you believe the agreement is?
We have the borrower sign the note and we give the borrower a check.
Does this agreement show the words borrower, lender, loan, interest, credit, or money within the agreement?
Sure it does.
According to your knowledge, who was to loan what to whom according to the written agreement?
The lender loaned the borrower a $200,000 check. The borrower got the money and the house and has not repaid the money.
Do you believe an ordinary person can use ordinary terms and understand this written agreement?
Yes.
Okay. Do you believe you or your company legally own the promissory note and have the right to enforce payment from the borrower?
Absolutely, we own it and legally have the right to collect the money.
Does the $200,000 note have actual cash value of $200,000? Actual cash value means the promissory note can be sold for $200,000 cash in the ordinary course of business.
Yes.
So, according to your understanding of the alleged agreement, how much actual cash value must the bank loan to the borrower in order for the bank to legally fulfill the agreement and legally own the promissory note?
$200,000.
Okay, so according to your belief, if the borrower signs the promissory note and the bank refuses to loan the borrower $200,000 actual cash value, would the bank or the borrower own the promissory note?
Well, the borrower would own it if the bank did not loan the money. The bank gave the borrower a check, and that is how the borrower financed the purchase of the house.
Okay. Do you believe that the borrower agreed to provide the bank with $200,000 of actual cash value, which was then used to fund the $200,000 bank loan check back to the same borrower, and then agreed to pay the bank back $200,000 plus interest?
No, if the borrower provided the $200,000 to fund the check, there was no money loaned by the bank, so the bank cannot charge interest on money it never loaned.
Okay. So if this happened, in your opinion, would the bank legally own the promissory note and be able to force Mr. Smith to pay the bank interest and principal payments?
Oh, I'm not a lawyer, so I cannot answer legal questions.
Well then, is it bank policy that when a borrower receives a $200,000 bank loan, the bank receives $200,000 actual cash value from the borrower, that this gives value to a $200,000 bank loan check, and this check is returned to the borrower as a bank loan which the borrower must repay?
Well, I do not know the bookkeeping entries.
I'm asking you if this is the policy.
Well, I do not recall.
Okay. Mr. Banker, do you believe the agreement between Mr. Smith and the bank is that Mr. Smith provides the bank with an actual cash value of $200,000, which is used to fund a $200,000 bank loan check back to himself, which he is then required to repay plus interest back to the same bank?
I am not a lawyer.
Did you not say earlier that an ordinary person can use ordinary terms and understand this written agreement?
Yes.
Okay. Okay, Mr. Banker, I'm going to hand you back the bank loan agreement. This is Exhibit B. Is there anything in this agreement showing the borrower had knowledge or showing where the borrower gave the bank authorization or permission for the bank to receive $200,000 actual cash value from him in the note and to use this to fund the $200,000 bank loan check, which obligates him to give the bank back $200,000 plus interest?
No, there is not.
Okay, so if the borrower provided the bank with actual cash value of $200,000 in the note, which the bank used to fund the $200,000 check and returned the check back to the alleged borrower as a bank loan check, in your opinion, did the bank loan $200,000 to the borrower?
In that case, no.
So if a bank customer provides actual cash value of $200,000 to the bank, and the bank returns $200,000 actual cash value back to the same customer, is this a swap or exchange of $200,000 for $200,000?
Yes.
Okay, so did the agreement call for an exchange or swap of $200,000 to be swapped out for another $200,000, or did it call for a $200,000 loan?
A $200,000 loan.
Good. So is the bank to follow the Federal Reserve Bank policies and procedures when banks grant loans?
Yes.
So what are the standard bank bookkeeping entries for granting loans according to the Federal Reserve Bank policies and procedures? And I'll hand you now the Banker Fed publication entitled Modern Money Mechanics, labeled Exhibit C.
The promissory note is recorded as a bank asset, and a new matching deposit or liability is created. Then we issue a check from the new deposit back to the borrower.
So then, is this not a swap or exchange of $200,000 for $200,000?
Well, this is the standard way we do it.
Answer the question. Is it a swap or exchange of $200,000 actual cash value for $200,000 actual cash value? If the note funded the check, must they not both have equal value?
Well, I'm sorry. I'm going to have to plead the Fifth Amendment on this.
Okay. Tell me, if the bank's deposits or liabilities increase, do the bank's assets increase by an asset that has actual cash value?
Yes.
Is there any exception?
Not that I know of.
So if the bank records a new deposit and records an asset on the bank's books having actual cash value, would the actual cash value always come from a customer of the bank or an investor or a lender to the bank?
Yes.
All right. Is it the bank policy to record the promissory note as a bank asset offset by a new liability?
Yes, it is.
Does the promissory note have actual cash value equal to the amount of the bank loan check?
Yes.
Then, does this bookkeeping entry prove that the borrower provided actual cash value to fund the bank loan check?
Well, yes, it does. The bank president told us to do it this way.
All right. How much actual cash value did the bank loan to obtain the promissory note?
Nothing.
Then how much actual cash value did the bank receive from the borrower?
$200,000.
So then, is it true you received $200,000 actual cash value from the borrower plus monthly payments, and then you foreclosed and never invested 1 cent of legal tender or other depositor's money to obtain the promissory note in the first place? Is it true that the borrower financed the whole transaction?
Yes.
Are you telling me the borrower agreed to give the bank $200,000 actual cash value for free, and that the banker returned the actual cash value back to the same person as a bank loan?
I was not there when the borrower agreed to the loan.
Do the standard Fed publications show the bank receives actual cash value from the borrower for free, and that the bank returns it back to the borrower as a bank loan?
Yes.
Okay. Do you believe the bank does this without the borrower's knowledge or written permission and authorization?
No.
To the best of your knowledge, is there written permission or authorization for the bank to transfer $200,000 of actual cash value from the borrower to the bank, and for the bank to keep it for free?
No.
Does this allow the bank to use this $200,000 actual cash value to fund the $200,000 bank loan check back to the same borrower, forcing the borrower to pay the bank $200,000 plus interest?
Yes.
Then if the bank transferred $200,000 actual cash value from the borrower to the bank, in this part of the transaction, did the bank loan anything of value to the borrower?
No.
Is it the bank policy to first transfer the actual cash value from the alleged borrower to the lender for the amount of the alleged loan?
Yes, it is.
Does the bank pay IRS tax on the actual cash value transferred from the alleged borrower to the bank as income?
No, because the actual cash value transferred shows up like a loan from the borrower to the bank, or a deposit, which is the same thing, so it's not taxable.
If a loan is forgiven, is it taxable?
Yes, it is.
Is it the bank policy to not return the actual cash value that they received from the alleged borrower unless it is returned as a loan from the bank to the alleged borrower?
Yes.
You never pay taxes on the actual cash value you receive from the alleged borrower and keep it as bank's property?
No, no taxes paid.
When the lender receives the actual cash value from the alleged borrower, does the bank claim that it then owns it and that it is the property of the lender without the bank loaning or risking 1 cent of legal tender or other depositor's money?
Yes.
Are you telling me the bank policy is that the bank owns the promissory note, which is the actual cash value, without loaning 1 cent of other depositor's money or legal tender, that the alleged borrower is the one who provided the funds deposited to fund the bank loan check, and that the bank gets funds from the alleged borrower for free? Is the money then returned back to the same person as a loan, which the alleged borrower repays when the bank never came up with any of its own money to obtain the promissory note? Am I hearing this right? I give you the equivalent of $200,000. You return the funds back to me, and I have to repay you $200,000 plus interest. Do you think I'm stupid?
All the banks are doing this. Congress allows this.
Does Congress allow the banks to breach written agreements, use false and misleading advertising, act without written permission, authorization, and without the alleged borrower's knowledge to transfer actual cash value from the alleged borrower to the bank and then return it back as a loan?
But the borrower got a check and the house.
Is it true the actual cash value that was used to fund the bank loan check came directly from the borrower and that the bank received the funds from the alleged borrower for free?
This is true.
Is it the bank's policy to transfer actual cash value from the alleged borrower to the bank and then keep the funds as the bank's property, which they then loan out as bank loans as if they actually owned it and loaned their own money?
Yes.
Was it the bank's intent to receive actual cash value from the borrower and return the value of the funds back to the borrower as a loan?
Yes.
Do you believe that it was the borrower's intent to fund his own bank loan check?
I was not there at the time, and I cannot know what went through the borrower's mind.
So if a lender loaned a borrower $10,000 and the borrower refused to repay the money, do you believe the lender is damaged?
If a loan is not repaid, the lender is damaged.
So is it the bank policy to take actual cash value from the borrower, use it to fund the bank loan check, and never return the actual cash value to the borrower?
The bank returns the funds.
Was the actual cash value the bank received from the alleged borrower returned as a return of the money the bank took, or was it returned as a bank loan to the borrower?
As a loan.
So how did the bank get the borrower's money for free?
That's how it works.
No more questions, Your Honor. All right, so there you have it. I think we've beaten that dead horse quite sufficiently, and the fraud should now be crystal clear.